This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, C-311. Be sure to stay connected with live sessions, catch up on past meetings, and explore our full archives anytime on the Senate of Virginia's YouTube channel. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, C-311. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, C-311. Be sure to stay connected with live sessions, catch up on past meetings, and explore our full archives anytime on the Senate of Virginia's YouTube channel. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, C-311.
We'll call this meeting to order. And the clerk will call the roll.
Senator Bagby,
Present?
Senator Suderline, Senator Aird, Senator Durant,
Present.
Senator Perry.
Aye.
You have a quorum, Mr. Chair.
Thank you. The committee will be at ease.
Thank you for joining us. This concludes this broadcast of the Senate of Virginia in Richmond, Virginia. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, C-311.
That incorporates a series of clarifying and technical amendments from the Bureau of Insurance.
Is there a motion?
So moved.
There's a motion and a second to approve the substitute. All those in favor express by saying aye. Those opposed? Senator Dees.
524 has its aim mental health parity, and I guess we've heard about that or talked about it and promised it for years, both at the federal and state level. We've worked really hard to reduce the stigma of seeking mental health treatment and invested a lot of money to grow our behavioral health workforce. But people who are insured and paying for health plans are routinely denied or delayed in care. Insurance companies are simply out of compliance with mental health parity requirements, at least what we think are requirements at both the state and federal level. We should not be making it more difficult for people to get the care they need, whether a plan is using outdated criteria to deny care, establishing inadequate networks, or adding unnecessary administrative barriers. The bill before you is the result of significant stakeholder engagement over the past several years and seeks to address these concerns. The bill does several things. Number one, the bill requires health plans to submit a comparative analysis prepared pursuant to federal law to the Bureau of Insurance and itemizes the information the Bureau shall request, including information about denied claims, prior authorizations, complaints, and appeals. The Bureau may ask for supplementary information and shall publish the analysis. Number two, the bill adds teeth to existing law and sets out the Bureau's authority for noncompliance, including imposing a penalty and or requiring the plan to make changes. Number three, the bill updates the definition of mental health services and substance abuse services. And number four, the bill authorizes the Bureau to promulgate regulations as necessary to implement the provisions of the bill. That's on line 425 through 428 of the substitute, and directs the Department of Health to adopt emergency regulations to implement the provisions of the bill. There are people here that want to speak in favor of the bill, and there are people that are opposed to the bill.
All right, 3 minutes for individuals that have opposition. Step right up.
Good afternoon, Mr. Chairman. Christopher West with Kaiser Permanente. I'm also speaking on behalf of the Virginia Association of Health Plans. Just want to start by saying we support parity for mental health and substance use disorder and medical surge benefits that's grounded in clarity, consistency, and administrative feasibility for health plans and employers. And we've worked tirelessly over the last 16 years to implement parity for behavioral health services. However, we are opposed to this legislation. I've not seen the substitute that was just released, so I'm speaking on what was the original bill. But the legislation permits Virginia to codify the 2024 MAPIA rule, which is currently not being enforced by the feds. The tri-agencies, which is the Department of Health and Human Services, Labor, and Treasury, issued a guidance on May 15th of last year, recognizing that they are not going to enforce the 2024 rule and encourage states to not also enforce. They are committed to future rulemaking to update guidance that will provide greater clarity and consistency. This is also caught up in the courts. What's known as ERIC, the ERISA Industry Committee, has sued the federal government over the 2024 MAPIA rules, and therefore the court has issued a stay on implementing those rules. We strongly believe that Virginia should not move forward with passing this legislation, and just want to close by saying that mental health parity was never intended to be an access framework. It is intended to make sure that med-surg benefits and mental health benefits are applied at the same level when it comes to access and prior authorizations. And so therefore we respectfully oppose this bill and would hope that we can continue to work on it and make sure it gets right. Thank you.
Good afternoon, Mr. Chair. Kyle Elliott on behalf of AHIP. Likewise, we have not seen the substitute either. However, at this time, we respectfully oppose SB 524. Echoing the sentiments of the prior speaker, we would just also urge the Assembly and the BOI to align with the federal Tri-Department's enforcement stay while the next steps are examined. However, even under this stay, other federal requirements are still in effect. The 2008 Mental Health Parity and Addiction Equity Act, the 2013 final MHPA-EA rules and subsequent guidance, and the 21st Century Cures Act, and the Consolidated Appropriations Act. We look forward to continuing to work with the patron to find the language that works, but at this time would oppose this bill. Thank you.
Those individuals that are speaking in support.
Good afternoon, Mr. Chair and members of the committee. I'm Rebecca Catterley. I represent the Behavioral Health Providers Coalition, which is a coalition of 16 behavioral health provider associations across the Commonwealth. We have been working on fixing mental health parity in Virginia for 3 years. We have consulted with the Bureau of Insurance, we've consulted with the Virginia Department of Health, and we've consulted with national experts to include the Kennedy Forum and the Legal Action Center in Maryland. What we're asking for is very similar to what they've done in Maryland and in Colorado and Washington. We have asked for we're asking for the insurers to be held responsible for mental health parity. We know that this is not happening in Virginia. We have evidence that there are more denials for mental health claims. Substance use claims are denied 51% more often. And because of the administrative burden, our providers are leaving insurance. Oh, thank you. Thank you, Mr. Chair. Yes. Providers are leaving insurance at an alarming rate, dropping from 50% network participation down to 37% in the last 2 years. People need help. Thank you very much.
Mr. Chair, members of the committee, Deborah Rodman, on behalf of the Virginia Counselors Association, we support this bill. We thank the patron for all the support and all the hard work that's come behind this bill. Thank you so very much.
Good afternoon, Mr. Chair. I'm Ophelia von Ludwig. I'm here to represent the Virginia Society for Clinical Social Work, and we are here in support of this bill.
Good afternoon, Mr. Chair, members of the committee. Trevor Monk here with the Psychiatric Society of Virginia and the Washington Psychiatric Society Northern Virginia chapter. We also support the bill. Thank you.
Mr. Chairman, members of the committee, Mark Smith, representing the Greater Washington Society of Clinical Social Workers. We very much strongly support this bill.
Mr. Chairman, members of the subcommittee, Mariah Fitzhugh on behalf of the Virginia Academy of Clinical Psychologists. We thank the patron for bringing this bill forward, and we highly support this bill.
Mr. Chairman, Becky Bowers-Lanier with the Virginia Recovery Coalition, and we are in support of this measure.
Mr. Chairman, members of the committee, Clark Barron with the Medical Society, we support the bill.
Mr. Chair, I think the reason why you see so many providers supporting this legislation is because if without parity, providers have no incentive to take insurance. And what access is denied, not only do we have a shortage of mental health providers in the Commonwealth, but as you heard Rebecca speak in the beginning, those providers who accept insurance has dropped to 37%. This bill is about providing access to people, and I apologize that the amendments were not available, the substitute was not available for people to see before we got here, but I assure you that the amendments are just technical. The purpose of the bill doesn't change. I'd hope you report the bill.
Go ahead. I'm going to move that we recommend reporting the bill to the full committee.
There's a motion and a second. Clerk will open the roll. Call the roll.
Senator Bagby?
Aye.
Senator Suderline?
Yes.
Senator Aird?
Aye.
Senator Durant? Senator Perry?
Oh, aye.
Senator Favola?
You have a microphone?
I know, like we can't hear you.
Oh, Senator Favola?
Aye.
Thank you very much.
Thank you. See you in full. Well, you don't have to come to full on this. Senator Lucas?
She's over there.
Yeah, she's coming. And then Senator Sturtevant, then McDougal. Hackworth, you want to come back in like 30? Or you want to watch all the festivities?
Good afternoon. Thank you, Mr. Chairman, members of the committee. Senator Locke just barely let me out of her subcommittee, but I'm here. I have an amendment, Mr. Chairman, if you'd like.
The amendment?
There's a motion and a second. All those in favor express by saying aye. Those opposed? Ayes 1, no 0.
Could we get counsel to just share that amendment with you? Yes. No, I have a copy. I just wanted you to share it with the committee.
Mr. Chair, Senator, this amendment, by the nature of the substitute, it's not ready to be posted on LIS yet, as it is currently going through the editing process, but it would add a requirement directing the state health commissioner in conjunction with the Secretary of Health and Human Resources or his designee, the VCU health system, and any other relevant stakeholders to develop recommendations on establishing and maintaining the Sickle Cell Coordinated Access Network for the purpose of providing healthcare providers in the Commonwealth with real-time consultation and support from sickle cell specialists. and it requires the commissioner to report its recommendations to the chairs of the House Health and Human Services Committee and Senate Committee on Education and Health by December 1st, 2026.
Thank you. Mr. Chairman, Senate Bill 813 creates the Coordinated Access Network to deliver integrated support for sickle cell care. The network seeks to bring support to providers throughout the Commonwealth to better treat patients dealing with this excruciating pain of sickle cell disease. Virginia has only a handful of sickle cell disease specialists concentrated in urban areas. The network will allow better access to specialized sickle cell care in rural and underserved communities. Delays in appropriate treatment lead to worse outcomes and higher costs for sickle cell patients. By passing this bill, we can help remove barriers to care, such as long travel times and lack of access to sickle cell specialists. This bill, Mr. Chairman and members of the committee, is in honor of Candace Gabriella King, a bright and talented 15-year-old who lost her battle to sickle cell disease. Our hope is to create a system that will better serve young people like Candace. We hope it will give them the opportunity to live long and full lives free of the pain of sickle cell disease.
Thank you, Senator. Any questions from the committee? Go right ahead, Senator Favola.
Thank you, Senator Lucas. This is, I think, a much-needed bill. As I understand it, it's primarily a work group that will keep track of providers who are knowledgeable and probably culturally sensitive in terms of being able to recommend care, or the network will have providers that are knowledgeable and culturally sensitive, and therefore patients would always know how to find a care. Is that it? Okay.
That's correct. It establishes the Virginia Sickle Cell Coordinated Access Network, which is a telehealth program providing every Virginia hospital with real-time access to sickle cell specialists.
I think it's a great bill, and
it's modeled on the successful Virginia Mental Access Program.
Thank you. Are there individuals to speak in opposition? Anyone here to speak in support? If you would go first, sir.
Thank you, Mr. Chair, members of the committee. Mark Hickman on behalf of VCU Health. We are very much in support of the bill. We thank the Senator and the Secretary for their leadership here. This is something that our sickle cell disease program already strives to do as much as we can, but with limited providers and resources. And so we look forward very much and are honored to work with the secretaries and the Department of Health on finding ways to expand access across the state. So thank you very much, and we look forward to it.
Good afternoon, Mr. Chairman, members of the committee. I am here on behalf of Virginia ACNM and the Virginia Midwives Alliance, and we support this bill. Thank you.
Thank you.
Thank you.
Thank you, Mr. Chair and members of the committee, for hearing this bill and that very thoughtful question. I'm here to share the administration's support of this bill. And on a personal note, I'm here to prevent any other parent from experiencing what I experienced a few months ago when I had to lay my 15-year-old to rest. Going throughout the Commonwealth and talking to families after Candace passed, we realized that the best care is happening right down the street. And when people live in Hampton Roads or in Northern Virginia or Southside, when the pain gets too unbearable, they say, "Take me to VCU." And unfortunately for us, we had great care, but there's something special happening at VCU that we want every family battling this painful disease to experience. And this is the first step of many to give kids like our Candace the opportunity to live long and healthy lives. And I thank BCU and of course the patron for taking on this bill, because the reality is sickle cell patients experience pain that is 2 to 3 times more painful than childbirth. There are all of the things happening, and for years no one was listening. I stood down the hallway and would give speeches and would say, listen, do something about sickle cell. And I never thought I would be standing here before you today as the mom of an angel, but here I am. And the senator has heeded the call to actually do something, and it is unique, and it will be the first of its kind in the country. And I hope that this committee will act favorably upon it.
Thank you. Thank you to those individuals that spoke on behalf of it. And also thank you, Secretary, Madam Secretary, for your steadfast work towards this issue. I think you know, and I hope you know, and I speak, I believe for both sides of the aisle on this, that although you have decided to leave us, this fight that you have, we are in this fight with you, and we will not leave you in this fight. And so thank you for continuing the work that you are doing in the administration, but also on this particular issue that I know that has hit your family so hard. And it's hit us hard. Yes. Because it hit you hard. And so thank you, Senator Lucas, for being a champion for a champion. And with that, do I have a motion?
So moved. Second.
There's a motion and a second. Clerk, call the roll.
Senator Bagby?
Aye.
Senator Suderline?
Yes.
Senator Aird?
Aye.
Senator Durant?
With honor, yes.
Senator Perry?
Aye by proxy.
Senator Favola? Ayes 6, no 0.
Ayes 6, no 0. Thank you.
Thank you kindly.
Thank you. Senator McDougal.
Thank you, Mr. Chairman. Mr. Chairman, I appreciate Senator Sturtevant letting me go ahead. I don't think I have any witnesses, but Mr. Chairman, this is Senate Bill 357. This was a bill that passed the Senate unanimously last year. This is not focused on the policy of decision makings with Medicaid. It is focused on the finances and making sure we can budget. I think that this is probably the most appropriate venue for this is in the Senate Finance Committee, but and it was Finance Committee staff that drafted the majority of this, but what this bill focuses on is the fact that we've missed the numbers, whether it's Republican administration or Democratic administration, we've missed the numbers and we've not been able to budget effectively for the cost. And this would lay out an independent agency that would report back to us, the House and Senate mainly, about where the finances with Medicaid are going. So I can go through each of the items if the committee would like.
Mr. Chair.
Senator Favola.
We do require multiple reports in the Medicaid space. So can you tell me how this proposed report would differ from some of the reports DMAS, say, has to provide to the federal government, and then we get copies?
Madam Chairman, this is, I think, totally different in that this is looking at the trends of cost and where those costs are coming from, and they come to the legislature and the executive branch on a monthly basis in order to flag them so that we don't get hit like this year with $1.5 billion, or I guess it was $2.5 billion this year. It was $1.5 billion last year. Right now, for all the things they do positive, DMAS has not been able to give us accurate numbers on these expenses so that we can budget. This is not to change the policy. That would have to come back before the body. This is so that we can appropriate resources accurately, and we've not been able to do that, and so we don't get surprised. So this was, Mike Tweedy was the one that drafted most of this this language in the attempt to make sure we were getting the
Getting
information
information.
in a timely fashion to be able to make financial decisions.
Is, Mr. Chairman, is DMAS here? Is there a representative from DMAS, and do they have a position on this?
Mr. Chair, Senator Favola, we don't have a position at the time on this. We're participating right now with JLARC, that's doing a Medicaid oversight study. Joint Commission on Healthcare did a Medicaid oversight study. So I think the devil's in the details with some of this bill, but we have no position as it stands right now. Senator Ayer.
Thank you so much. This is for DMAS. I just wanted to confirm, and can you just correct me if I'm wrong, that right now the internal oversight mechanisms within DMAS include the Office of Compliance and Security, the Office of Quality and Population and Health, Sanction Authority, Appeals System, Financial Contract Oversight. Is that factual?
Yes.
Follow-up question, Mr. Chair.
Senator Ayer.
Further, I just wanted to confirm whether or not you felt like DMAS has not been able, do you believe that DMAS needs an additional oversight authority for internal controls?
So, Mr. Chair, Senator Aird, I think DMAS would agree that there is some room for oversight. We're participating in some studies right now. DMAS has dashboards and websites. We report on financial information. I think, again, it's the details of the bill that would need to be discussed a little bit more, a separate agency, things like that. But there already are oversight in existence, and I think there's room for some additional oversight. The question is just how that would work.
Final question, Mr. Chair.
Senator Ayer.
So right now in this legislation, it actually is a very robust bill from what I can tell. The legislation will require that this new agency head provide or mandate from DMAS that it provides its office with 30 days notice before implementing any changes to its programming. It also gives this agency fiscal veto power. It also gives this agency the ability to have both legislative and executive, from what I read, requirements, and then it has requirements for mandatory cooperation. To me, that sounds like it goes beyond just a few additional internal controls. So do you have objections to any of those additional elements that this would now put in place over top of DMAS?
So, Mr. Chair, Senator Aird, so I think, again, I think the issue is a separate agency and kind of how that interaction is. Yes, that I think we would have some concerns with, but there is agreement that there should be some discussions of additional oversight where we are now, how we could grow. I don't know that this would be the answer to that.
Thank you, Mr. Chair.
Mr. Chairman, if I could maybe address some of the Senator Aird's questions. This issue came from a couple years ago when we started missing the budgets. And that was the forecast that we're coming, how much we're spending. Everybody thinks that this is an important area, and it's our largest growth area. And so how can we get those numbers accurately so that we can make sure we're funding other things? I think the specific lines that you referenced would be changes that would be made by DMAS that were not authorized by the General Assembly or not authorized by CMS, that they would not be able to be implemented unless there was authorization from the legislature, to make sure that the legislature knew what changes were going to be in place and what financial impact it would be. So in my view, that's written to give us more control over it, to make sure things were not moving that we're not aware of. And Mr. Chairman, Sir Aird, the second piece of that is the information request is to make sure that everybody is aware of where those numbers are coming. When we miss it by $2.5 billion like we did this year, and at first we thought it was going to be $3.1 billion, and then it was 2.5. It makes it very difficult for us to budget for things like teacher pay and transportation and all the other social safety nets. So that's the thing. This was not oversight in telling DMAS what you have to do, but oversight in getting the accurate information so that we can properly budget. And if DMAS was and I would assume that they wouldn't love this, but if DMAS was going to make a change that was not authorized by the legislature or not authorized by CMS, so they were required to do it, then it would have to come back to us before it would move forward. So that was the effort to make sure that we as a legislature had greater control going forward.
Senator Aird.
Thank you so much, Mr. Chair. Senator McDougal, I do want to make sure that I am tracking the intent of the bill. I appreciate the context regarding the past financial situation that led to the conversations for this bill. I think my concern is, to me, it feels far more robust than just the fiscal tracking and the fiscal accountability. I think my greatest concern is setting up an agency that could potentially be at odds with DMAS from time to time. It looks to me that if, in some instances, the DMAS makes a decision, that this agency has the ability to block that decision. To me, it appears that we have basically a duplication of efforts by standing up what would seem to me to be two competing agencies. And so I'm just trying to figure out how that's efficient when what it sounds like is we need to fix the House DMAS if there are internal control issues that has resulted in the dynamic that you described.
Mr. Chairman, Senator Aird, so again, if that's one of the provisions, I think there are
Several
others. So if that's one provision that the committee doesn't like, certainly understand and take it out. But in previous Democratic administrations and Republican administrations, we're not getting it right, and it hadn't been right for a number of years. And the cost to that is we can't spend our resources in other places because we're not able to budget appropriately. So Republican administrations and Democratic administrations have not been able to get that accurate. So the concept that we came up with was an independent that the legislature has greater control over to make sure we're having that. And you might disagree with that, but I know what we're doing now is not working, and the cost of that not working is about $4 billion in the last couple years. So.
Final question, Mr. Chair.
So this is an attempt to try to address that.
So I'm sorry if I missed it. Thank you, Mr. Chair. Can you clarify, was this, you said the concept that you came up with, was this a recommendation of JLARC? Has JLARC already conducted a study? Who has made the recommendations that make up this omnibus bill?
Mr. Chairman, Senator Aird, this was, and I did not pull the previous one, but a similar version of this passed 40-0 out of the Senate last year. It was the House that gave some objection to it. This came from Senate finance conversations over the last number of years. It wasn't just a one-year process, and it's developed, and the Senate finance staff drafted most of this language to try to deal with the challenges that we've seen. So historically, this bill has gone to Senate finance because it was partly their brainchild of how to deal with some of the forecasting that we've not been able to get accurate. If that makes any.
Thank you. Mr. Chair, at the appropriate time, I'd like to speak to the bill, but I'll allow for the.
Senator Aird.
Is it now, the time? Mr. Chair, Senator McDougal, I really appreciate the multi-year effort that has gone in trying to determine the best approach that we need to take because we have had such a fiscal challenge. I personally don't feel comfortable hearing DMAS unofficially declare that they also agree and they would like to figure out how to either add additional controls within their agency or even have further discussions about tightening some fiscal, increased responsibility. I'm actually not even in opposition to having some external controls like what you are trying to establish. However, I do feel very uncomfortable without more individuals part of this conversation, such as somebody like JLARC, who we have as an agency to do this type of research and to make sure that if we stand up an agency of this nature, that it is based on what DMAS already has in place, where the failures have occurred, and what powers are actually needed. The structure that this legislation takes, I think, duplicates some of what the work DMAS is responsible for. And further, I think it establishes an agency to be at odds with DMAS. And so I personally feel like we should try to give JLARC the opportunity to take a closer look at this before we adopt something this significant. Thank you, Mr. Chair.
Mr. Chair, again, I certainly understand what Senator Aird has articulated. I think that if we do not move something forward, then we're going to find ourselves here again next year with a same significant cost increase, and we're not going to know where it came from or have any information about how to address it. So this is an effort to try to come up with that. And Mr. Chairman, I would say that this does remove some of these forecasting directives from DMAS, in part because we've not been able to get it right. So we need to find a way to get it right because it's not happened for a good while.
Mr. Chair,
Senator Favola.
I think I'm going to move that we carry this bill over. I agree with the intent, but I am also very sympathetic to Senator Aird's points about, I think we need more stakeholders looking at this to come up with maybe recommendations that have a broader, represent a broader perspective on how we can get DMAS to come up with reports that might be more accurate and more meaningful. At the end of the day, I keep being told that their systems are outdated. They have some administrative challenges, and maybe staffing is an issue. So there are lots of things going on besides just the lack of accurate information, and I would like to sort of address some of those other issues, especially given the impact of the federal HR 1 and how we're going to implement the new changes to the Medicaid expansion rules.
Second.
There's a motion and a second to carry the bill over. Clerk, call the roll.
Senator Bagby? Senator Suederlein? No. Senator Aird? Senator Durant? No. Senator Perry? Senator Favola?
Mr. Chairman, thank you.
Thank you, Mr. Chairman, members of the subcommittee. Good afternoon. This is Senate Bill 808 that is before you. Mr. Chairman, members, Virginia Medicaid has a quality bonus program for nursing homes. It is extra money on top of the regular Medicaid payment that we provide to nursing homes in Virginia. And the point of that bonus payment is to reward for facilities that are meeting their quality goals and improving care. And so what this Senate bill is about, 808, is about making sure that that bonus money stays aligned with that purpose. And so the issue that has come to light, specifically in my district as well as in Henrico County and around the Commonwealth, is that you have a situation where you have a parent company that owns a nursing home, and that parent company also has a separate company that owns the building that the nursing home is in. And the challenge that we are seeing is that the sister company that owns the building will set an unusually high rent on the building that they then charge back to their sister company, the nursing home that is using that building, and then those profits go up to the parent company. And so what this bill would seek to do is make sure that our Medicaid bonuses that are supposed to be going for patient care and improving outcomes for the patients that are in nursing homes in Virginia, that money is actually going to that and not being used in this shell game situation where you have 3 or more different entities that all know how much revenue and expenses the nursing home has, and then the rent from the nursing home building can be increased to siphon out that money for the parent company corporate owner. This bill does not tell the nursing homes how much they can charge for rent. It does not rewrite their leases. It simply sets a rule for how Virginia is going to pay those Medicaid bonuses. And so here is how the guardrails work, Mr. Chairman. Virginia Medicaid already uses fair rental value in its nursing facility payment system. And so this bill uses that existing fair rental value concept as the benchmark. If the facility's related party rent is above 125% of that benchmark, then the amount above that threshold is deducted from the quality bonus that the Commonwealth would otherwise be obligated to pay them. And so let me just give you a concrete example so you can understand exactly what we're talking about and what the bill does. For example, if DMAS were to determine that a particular facility's fair rental value was $2 million a year, $2 million to rent this facility to operate a nursing home, we have a cushion built into this bill of 125% of that fair rental value. So that gives them a cushion of up to $2.5 million. So if the facility is paying $2.3 million, for example, my bill doesn't apply, nothing changes, they still get their full bonus money. But if the facility is, for example, paying $3.1 million, so much higher than that fair rental value, then the quality bonus is reduced by how much over the fair rental value they are. So in this example, it'd be $600,000 over the fair rental value. So the DMAS would reduce their performance bonus by $600,000. And that way, we don't have this situation, which really concerns me, where the sister companies, the nursing home is getting this bonus money from the state. The sister company that charges the rent knows, because they're the same company, they're affiliated, they're related parties. The one charging the rent knows how much bonus money and how much revenue they're bringing in. And so what we don't want to have is they find out, okay, nursing home's getting a $500,000 Medicaid bonus from DMAS. Oh, our rent's about to go up by $500,000 this year, because then that's just sucking out that bonus money that's supposed to be going to making people better and taking care of them. So that is essentially the bill. I've worked to make it fair and workable in the real world. So DMAS has to provide written notice and explain their calculation to the nursing homes. The facility has the ability to appeal under this bill. And then DMAS can even waive all or part of the reduction in the bonus if there's a legitimate reason for the higher rent 1 year. So for example, if they can document that they made capital improvements and that's why they got to charge higher rent, or if there's unusual market conditions in a particular locality, they can go and show that they have good cause as to why they went above that threshold. But the idea is, again, very simply, the Medicaid bonus money should be going to providing better care. And we have now in Virginia these corporate structures that can allow for the abuse of that system. And so this is a way to help prevent that. And that's the bill.
Individuals are here to speak in opposition. Come on up. Start the clock, please.
Mr. Chairman, members of the committee, I'm Scott Johnson. I'm General Counsel for the Virginia Healthcare Association. We represent approximately 97% of all nursing home beds, whether nonprofit, for-profit, or governmentally owned. I want to thank the Senator for meeting with us. We are opposed to this bill. There are a number of problems with it. Number one, nursing homes today, pursuant to federal requirements, have to file rent payments and say who they are filed to. The Senator's bill talks about related parties. The lingo for the feds is related organizations, so that's already being done today. The second thing, you've already addressed this session, a major piece of the concern the Senator articulated in passing from this full committee, 14-0, Senator Favola's Senate Bill 247, that talks about when you have a sale of a nursing home, that the incoming operator has got to come in and provide information to VDH, show how they've behaved in Virginia and other states, and also it's got to be revealed payments of rents or other contracts along those lines, so that's already being done. The second thing, this bill presumes an assumption that payment of rent correlates to how quality is going to be delivered in a facility. We want the highest quality, but if I've got an old facility and I put money in new roof, new washing machine, hiring staff, my rent may be higher than a facility that's 10 years old that's still in pretty good shape. To ask DMAS to come up with a fair market value is a monumental task. They do it in a very narrow situation now, but they don't consider capital cost for Medicare payers or commercial payers. So you're asking us to be judged to a system, and this bill as drafted would apply to existing agreements and disrupt them. I brought with me today the chairman of the Virginia Healthcare Association, Wendy Walters, as well as Ashley Jackson, so that you can hear from the trenches exactly what this bill would mean if it were to pass. We ask that you PBI it.
Good afternoon. Thank you for the opportunity to provide comments today. My name is Ashley Jackson, and I'm the Regional Vice President of Operations for Sabre Healthcare Group. We represent 33 nursing homes across the Commonwealth, including several homes in the districts of senators here today. If you don't recognize the name Sabre Healthcare Group, here's what's important to us. We've been committed to providing high quality of care in the Commonwealth for the last 2 decades. We're focused on a partnership that yields fundamental changes to our system, one that allows good long-term care providers and our residents to thrive. That's a system that's built on quality metrics and quality care. But this bill, while well-intended, won't further those efforts. Rent has no proven link to quality metrics across the Commonwealth. Our value-based program, a program built on quality of care metrics and the improvement of daily staffing, is an exact example of our goal. Furthermore, this bill will create duplicative processes, allow for the public to make unfair assumptions regarding fair market rental value for skilled nursing facilities with no basic knowledge of the calculation or varying aspects of rent in long-term care facilities, such as age of the physical plant, the date of purchase, or the inclusion of future capital projects within the financial payments. We're committed to accountability, transparency, and quality. That's why we're supporting Senate Bill 247, for instance, which gets at the heart of this issue, strengthening the change of operator process to ensure we have a better vetting system for new providers. And we've advocated for budget amendment language that gives us an opportunity to reshape quality incentives in the Commonwealth. In closing, I want to emphasize we are committed to quality. We understand the goal of the bill. However, our concerns remain. We remain unwavering to making these changes in other ways which can provide more efficiency and emphasis on quality of care metrics. Thank you.
Good afternoon. I'm Wendy Walter, Regional Director of Operations for Commonwealth Care of Roanoke, and serve as on the Board of Directors as Chair for the Virginia Healthcare Association. VHCA VCAL supports transparency, quality improvement, and restoring public confidence in Virginia's nursing homes. However, we have serious concerns about Senate Bill 808 because it does not advance those goals and provides no real benefits to residents or families. Senate Bill 808 requires nursing homes to post all rent or lease payments on their websites, regardless of whether the payment is to a related party. These figures, taken out of context, can sound alarming, but are not meaningful indicators of quality. Rent amounts alone do not explain how care is delivered or how residents are treated. The bill is built on the incorrect assumption that the quality of care a resident receives is tied to how much a facility pays in rent. There's no evidence that higher rent results in poorer care. Yet Senate Bill 808 would reduce value-based incentive payments based on rent levels rather than actual care outcomes. This undermines the very purpose of the value-based program, which is designed to reward quality, resident outcomes, and performance. If a facility meets quality benchmarks and delivers good care, it should receive the incentive it has earned. Reducing those payments based on unrelated financial arrangements could limit a facility's ability to invest in staffing, training, and facility improvements. Fair market rent cannot be standardized. It varies by location, age of the building, financing structure, and local debt markets. Directing the state to impose a rigid methodology risks arbitrary results and could disrupt existing lease arrangements, including those guaranteed by HUD. We respectfully ask you to oppose Senate Bill 808 because it ties financial assumptions to quality outcomes without evidence and risk harming rather than helping resident care. Thank you.
Mr. Chairman, members of the committee, Matt Benka representing the Virginians advocating for seniors. We represent over a third of the beds in the state. The level of complexity that is involved in these relationships are a lot more complicated than you might think. The bill just came up this session. We didn't discuss it beforehand. We strongly encourage you to PBI it, and we'd be glad to work with the senator in the off session. Thank you.
A message. Those who want to speak in favor.
Good afternoon, Mr. Chairman. Jared Calfee with AARP Virginia. We support the bill. The senator did a good job of laying out the system of related parties with nursing home facilities and how they work. It's been estimated that up to 40% of public money goes to related parties from nursing homes. And I wanted to highlight a couple things from the National Consumer Voice for Quality Long-Term Care did a report on related party transactions in 2023. And they found that the amount of money paid to related parties far exceeded the costs reported by the related parties. So both related parties and the nursing facilities have to report to CMS on costs. And I'll give you one example. A large nursing home chain, their related parties reported providing services with a cost of around $482 million from 2018 to 2020. But meanwhile, the company reported paying these related parties about $570 million over that same time period. The cost report does not require an explanation of that difference or where that extra $88 million actually went. And in some cases, the payments to related parties exceeded reported costs by nearly 1,200%. Looking here in Virginia, Colonial Heights Rehab and Nursing Center paid $2.6 million to a related party landlord in 2022, and just 2 years later, they were paying $6.1 million for the same facility. So this is a big problem. We think that this bill will improve transparency and make sure that public money is actually going to quality of care for residents and not to fill the pockets of ownership and increase their profits. And so we'll hope you support the bill. Thank you.
Good morning, Chair and members of the committee. Emily Hardy with the Virginia Poverty Law Center. For the reasons already stated, and because this is specifically focusing on bonus payments, not fundamental underlying payments, we support the bill, and we ask that you do as well. Thank you.
Thank you for clarifying.
Thank you so much, Mr. Chair. Please forgive me, I do have like 3 questions. The first one is for council. There was a reference made to Senator Favola's Senate Bill 247, and I wanted to clarify whether or not this Senate Bill 808 conflicts with what we have already made a policy decision on regarding Senate Bill 247 already.
Mr. Chair and Senator, reviewing SB 247, what it largely deals with is change of operators and the application process and the information that they have to provide when there is a change of an operator. The bill in front of you today, SB 808, does have some language about when an operator changes. It's part of the disclosure process that they do have to submit certain information to DMAS in that situation. But the large portions of the bill in front of you today do not conflict with what's in SB 247, and it's a little bit more expansive in who it covers and what it requires out of the nursing facilities.
Thank you so much, Mr. Chair. Question for the patron. I was just really wondering, you shared a lot of information, and as stated, this is very complex, but can you either reiterate or simplify the existing financial disclosures as compared to what you're, the way you're asking for that to be expanded upon, or I understand the transparency part of it, but I'm really trying to get at the root of the complexity of the financial relationships, and so what's required now and what you're asking to be added to that requirement.
Yes, Mr. Chairman, Senator Aird. So the 10,000-foot level is we're trying to make sure that related parties, which have common ownership ultimately at the top of the pyramid, are not charging each other excessive rent when dealing with a Medicaid recipient nursing home, because those are tax dollars. And so what would be different about this bill is DMAS already comes up with a fair rental value as part of their process. This would build off of that concept so that there would be a fair rental value for every nursing home that has a related party that owns the building that they rent back from. So again, two sister companies, one operates the nursing home, the other owns the building that rents it to them. And so what is not currently done now, but what my bill would do, is that if there is excessive rent charged between those two related entities, that's allowed, but we're not going to pay the Medicaid bonus money to help contribute to that excessive rent payment, essentially.
Before you go forward, Mr. Chair,
Go right ahead.
the mechanism to prevent the bonus payment looks like what? So like if this, like I'm gathering that this is transparency, but if it's determined that you sort of have this conflict that you're describing, what is the actual mechanism that would?
It's DMAS looking at the fair rental value that they've determined versus the rent that has been charged and paid by that nursing home to its sister company over a defined time period set by DMAS.
And so, Mr. Chair, would this look like them also reviewing these postings, or is this a submission to them? I'm trying to figure out, like, how do you actually?
One of the concerns raised by the Nursing Home Association was having to post this stuff on their websites. If it's the will of the subcommittee, if there's a desire to keep this moving and to take that piece out, I'm fine with that. That's more of a public transparency thing. But as long as this information is provided to DMAS, and DMAS can compare what the rent payment is to what the fair rental value is, and if the delta is excessive, then the state can hold back that bonus money. That's really what I'm looking to accomplish with this bill.
Thank you, Mr. Chair.
I'm very sympathetic to what you're trying to do. Obviously, I put in a bill that addressed new ownership and what was required, and gave our licensing department the authority to deny new applications. So I am very aligned with where you want to go. I think the bill has some implementation issues, though. I mean, we really can't make a direct correlation between a rent payment and the quality of care that's going on in the hospital. The Joint Commission on Healthcare was looking at standards of care. What should the ratio be of, nursing staff, or in this case, CNAs to patient? And then, we came up with something that's a little flexible, because we actually considered the complexity of the cases. But at the end of the day, if the incentive payment should be directly related to the quality of care, and not necessarily to some other things like the payment of rent or maintenance or the physical amenities in the building. And this information, by the way, is required to be reported on federal forms. I think, because this is not fully cooked, and this is it's of course up to the will of the subcommittee, but I would be more comfortable, again, carrying this over and maybe having a letter go to DMAS and outlining factors that might directly relate to the quality of care that would benefit from some public oversight.
Senator Sutherland?
May I just respond by that to Senator Favola's comment briefly? Thank you, Mr. Chairman. I understand that, Senator Favola, and of course it's up to the will of the subcommittee. The comment about the correlation between the rent and the care was something that I had heard from the nursing home folks. I would contend that that's really not what this bill is about. What this bill is about is making sure that the money, the bonus money that we are providing that's supposed to be for the patient care and supposed to be for more physicians and more nurses has the potential to be abused and not used for those things. And so what this bill seeks to do is say we're not going to contribute to those profits being sucked out of a company under the form of rent. And again, there are real world examples of this happening in districts that we represent in Colonial Heights and Henrico. And again, as the chair of the full committee, if a letter were to go to DMAS, I don't know if there is a work group or something that has the ability to work on something like this, but I think that there is a larger issue going on, especially from what I have heard throughout this process. There's a larger issue around the state, and I think that there's a lot of tax dollars that could be going to taking better care of grandma at a nursing home that is unfortunately going more to corporate profits than to that. And that's what I'm ultimately trying to address here.
Thank you, Mr. Chairman. Mr. Chairman, I don't think that we ought to do that. I think we ought to move forward with the bill. It was amazing to hear the testimony of the opponents of this legislation and who represent folks that receive substantial taxpayer support to provide care for older Virginians, and have them come up and speak with the intensity about how this needs to be PBI'd, which is not something you hear very often from professional advocates, but we heard it at the beginning and the end of that lineup. I thought that was completely out of line, and I find it very concerning that they do not want any continued discussion of this subject. So I don't want us to continue it to next summer. I think we ought to advance it now and continue the conversation during this General Assembly session. And I think everyone ought to be really concerned by that testimony that we just heard from folks that represent people that receive so much taxpayer money to care for our older Virginians that are in vulnerable states. And that was incredibly concerning, and I'm shocked to have heard that from professional advocates. Thank you.
No, sir.
Mr. Chair.
Yeah, I'll make a motion.
Senator Durant.
Thank you to the patron for bringing this. There's a lot to unpack and digest with this, and I'm just curious, I guess, to the patron, we've had a couple of different ones, in terms of the outcomes of whether or not we're going to continue this, and if there is a potential work group, or if we continue forward with the committee. And again, it's up to the will of the committee how we're going to recommend moving that forward. But I guess if there's is a continuous moving forward, if that's that for the discussion, do you feel that there's going to be some, I guess, potential to try to address some of the opposition concerns that we heard about going to really about the quality of care?
Yeah, Mr. Chairman, thank you, Senator Durant. I am always willing to be constructive and work together, and I'm happy to sit down and try to redline this thing in a way that is true to the intent, but also addresses real-world challenges that they may identify. If it were to proceed out of this body, it's obviously still got a long way to go, but keeping the conversation going, I think could be beneficial.
Mr. Chairman, I at least feel like I'm going to make a motion, and everyone else can act how they want, but I move that we recommend report.
And I have a substitute motion.
Substitute motion?
My motion is that we carry this over with a letter, and I'm willing to send a letter to the Joint Commission on Healthcare to actually come up with a total look at what kinds of factors we need information on to make judgments regarding quality of care and our incentive payments, because you raise a very good point. I mean, our incentive payments need to be used to improve the care being given at that facility. And I don't think you made the case that the rent is necessarily related to the quality of care, but you did make the case that money is being spent. And maybe we need to look at that in a more complete picture. We need a more complete picture, but you have raised an important issue. And I'm very willing to work with you and the Joint Commission on Healthcare. If that's the right place to send it, I will ask staff, is there another place that we should, thank you. Is there another place that would be better equipped?
There's a motion and a second.
Yes, I was where the letter.
Did you make the motion or you got a question?
No, I made the motion, but I had suggested sending a letter, but I did not.
Is there also a question to see if there's?
I did not confirm where the letter should go, and that is my question.
So let's hold off on the motion. Let's get the question answered.
Mr. Chair, Senator Favola, it seems like that would be the appropriate body, but I'm happy to confirm that with the members of the subcommittee if you'd like me to look into it further.
Okay, then my motion stands.
Second.
There's a motion and a second. Clerk, call the roll.
Senator Bagby?
Aye.
Senator Suderline?
To continue?
With a letter to the Joint Commission on Healthcare to evaluate.
No, I'm a no on continue.
Senator Aird? Aye. Senator Durant?
To confirm, this will be continued over to work on this to the next session with a letter. Is that correct?
It is.
Right.
All right, well, I would support that over definitely not killing this. I do want to see this continued.
Okay. And I'm an aye.
Senator Perry?
Aye, by proxy.
Senator Favola?
Aye. No, it's.
Ayes 5, noes 1.
Ayes 5, noes 1 will,
Thank you.
yes. Senator Jones. And then Senator Head. I couldn't even see her.
Thank you, Mr. Chair. Members of the committee, I have before you today SB 740.
Go ahead.
Yes, sir. 740, SB 740 is a bill that aims to help prevent veteran self-harm, veteran suicide through innovative medical treatments. Basically, it creates an advisory council. Bill establishes a breakthrough therapies for veteran suicide prevention advisory council within the Department of Health. This council will have 6 members appointed by the governor, House of Delegates, and the Senate. Council members should have the expertise in areas like PTSD, treatment, traumatic brain injury, veteran mental health care, and FDA breakthrough therapies research. The council will advise on how to distribute grant money from a special fund created to support breakthrough therapies for veterans. If the federal government changes the classification of any FDA breakthrough therapy drug, the state's board of pharmacy must make similar changes to the state regulations within 30 days. A council appointment within 60 days, recommendations on fund use within 120-day fund distribution within 100 days of money becoming available. In essence, SB 740 creates a framework to evaluate and implement innovative treatments that could help prevent veteran suicide with a focus on breakthrough therapies that show promise for conditions like PTSD, depression, and traumatic brain injuries. Mr. Chair, this was a bill that now Lieutenant Governor, State Senator, former State Senator Ghazala Hashmi brought last year, and one of my constituents who is a member of the Board of Supervisors in Chesterfield, something that he has advocated on and for the past couple years.
All right, and I believe this needs to go to finance, am I correct? And are there any individuals that want to speak in opposition to this? All right, if there's a motion to report and re-refer to finance.
Second.
Right.
Mr. Chair, I think we do have time to send it to the full committee on ed.
All right.
And then.
Yeah,
re-refer
to
it.
recommend report and re-refer to finance.
Second.
There's a motion to report and to recommend reporting and re-refer to finance. Clerk will open the roll.
Senator Bagby?
Aye.
Senator Suderline?
Yes.
Senator Aird?
Aye.
Senator Durant?
Yes by proxy.
Senator Perry?
Aye by proxy.
Senator Favola? Aye 6, no 0.
Thank you. That'll.
Thank you, Mr. Chairman. For the committee.
No. Senator Hayes.
Thank you, Mr. Chairman. I have three for you. The first one's going to be really, really fast, and that's Senate Bill 244. This is brought on behalf of the Virginia Association for Home Care and Hospice, and after we submitted the bill, Governor Spanberg issued Executive Order Number 2 that basically does the same thing as a part of that, and so the request that they have made for me is that we ask you to strike the bill. So if you would recommend striking the bill at patron's request. Okay, thank you. Now, Senate Bill 239, we started on this one last week, and at the subcommittee's request, took it by to try to get the stakeholders a chance to work this out. This is the Certificate of Public Need bill for medical deserts. As it turns out, I don't think they've been able to come to anything yet. Part of that has just been scheduling between the two because they've all been working on a lot of different things, and we're moving pretty fast here. There has been a request that it be referred to the State Services Plan Task Force for a second year. If that is the committee's desire, then obviously that's what we will do. I'm a little concerned because that would be the second year in a row that it's been there, and they didn't come up with a recommendation of what would be expedited review. And we really need them to we need them to get down to this if that's what it's going to be. But would love to be able to find some way to move something forward. But I will leave it with you unless you want to hear from any of the stakeholders that are here, because I think we've got folks in the room watching.
Mr. Chair, a question for the patron. So I would like to recommend that if it's been determined we need to send this back to the State Services Task Force, that maybe, and Mr. Chair, Council, I don't know if this could be instead substituted as a Section 1 with reporting requirements as outlined based on this language with a deadline of October, whatever deadline we've been using this session, so that we ensure that a report actually gets back with a recommendation.
So, Mr. Chair, if I could just to clarify, so that we would say, convert it to a Section 1 bill and say, you shall do this by October 1.
Correct.
Give us this language. If that's because if that's where we've got to be, I think that would honestly that would light a fire as necessary. So,
Mr. Chair, I think that would be helpful because they have not come up with criteria for an expedited review. And this would be for underserved communities with respect to primary care services. I think that's the way the report would read, because that's what we're gleaning from your bill.
Yes.
I do want to thank you for sort of working with us over the weekend, and I'm sorry we couldn't come to agreement, but having a report back to the general.
These things do take time.
They take time. So shall I make a motion for you, which you just said? Yes. Okay. Well,
so that would be an amendment in the nature of substitute that you would adopt in concept now, and we would do that at full committee on Thursday?
Correct. So. Now, the Section 1 bills usually go to rules, but how can we get around that?
Mr. Chair.
I hope the rules be.
Mr. Chair.
Somebody said that out loud? I didn't say.
Mr. Chair, Senator, Section 1 bills are only recommended to go to rules if they're establishing a work group or a study. If they're
We'll just direct the state,
Yes.
we'll just direct the plan to come up with the expedited review criteria and report to us.
to do the-
No stakeholder group, we're just directing them. Wonderful.
There's a motion and a second. Clerk, call the roll.
Senator Bagby? Senator Suderline? Senator Aird? Senator Durant? Senator Perry? Senator Favola? Ayes 6, no 0.
To the full committee on Thursday.
All right, thank you. And then finally, we have Senate Bill 677. This is correcting an anomaly. We have a situation where a variety of custodial care operators, there are about 6,900 of these in the Commonwealth, and it can be anywhere. They're regulated and overseen by the Virginia Department of Education under the Child Day Program. And these are places that are known as family day homes, which provide daytime care for a maximum of 12 children. The Virginia Department of Social Services that has certain assisted living facilities that care for no more than 12 residents, and the Department of Behavioral Health and Developmental Services. We have some of the group homes that are dealing with 12 or fewer adults or children and provide 24-hour services for those with mental illness, developmental disabilities, or substance abuse. The problem is that all of those facilities currently, because we left something out in a revision of the code previously, they are classified as restaurants if they are preparing food. And as such, they have to meet all of the standards of being a restaurant, but these are also a home. There is also an anomaly, even if they could get to that they can't, that the restaurant code says that you can't serve in a restaurant anything that was prepared in a home. So there's an inherent inconsistency with this. And so what we want to put into place is the exemption for them to be able to prepare the food.
Thank you. Anyone here to speak in opposition? Anyone here to speak in support?
Move to report.
There's a motion and a second to report. Clerk will call the roll.
Senator Bagby?
Aye.
Senator Suderline?
Yes.
Senator Aird?
Aye.
Senator Durant?
Aye.
Senator Perry?
Aye by proxy.
Senator Favola? Ayes 6, no 0.
Thank you very much.
Thank you. Senator Carol Foy, I told you to come back, but Senator Boysko, I believe, needs to leave.
No worries.
All right. We just want to make sure she's clear that she owes you a favor.
Thank you.
Senator Boysko.
Thank you, Mr. Chair. I appreciate it. I'm being asked to go upstairs to work on something. This is a very sensitive issue, and I just acknowledge that people here have really strongly felt beliefs about this. SB 359 would allow adults with terminal illness to request medication that they can self-ingest so that they can have some control over their end of life. I have an amendment that is in response to some concerns that I have heard from members, and I would ask that you could move that.
Move the committee amendment.
There's a motion and a second. All those in favor express by saying aye. Those opposed? Ayes 1, no 0.
Thank you, Mr. Chair. So the committee amendment would recommend that participating healthcare providers who provide this medical aid in dying to qualifying patients would complete evidence-based implicit bias training to better identify the unconscious prejudices that they may have that may affect patient care and outcomes and contribute to health disparities. That's the amendment, and you have just approved that. So the Senate passed this bill in 2024 when then Senator Hashmi carried it. You may recall that our former colleague, former Congresswoman Jennifer Wexton, made a very passionate plea asking for this policy. And my bill is almost exactly the same, but I think we have a few more guardrails on it that could make it more palatable to people who had some concerns. The bill only applies to adults who have been diagnosed with only 6 months or less to live. It is limited to residents of Virginia. It provides qualified patients additional health care options when facing a terminal diagnosis. I would like to just go through exactly what it is before I ask my people to come up, but they have to be 18 years old. They have to be able to make informed healthcare decisions. They have to have an incurable and irreversible disease with a terminal illness of 6-month prognosis. They have to make an initial request to their attending healthcare provider. Then they must make a second oral request to their attending healthcare provider, but they can only do it 15 days or more after that initial one. The attending healthcare provider must evaluate the patient to confirm their eligibility for aid in dying medication in a one-on-one meeting with the patient to ensure that the patient is acting voluntarily and not against their will. The attending healthcare provider must confirm that the patient understands the diagnosis and the prognosis, the potential risks and the probable outcomes of taking the medication, and inform them of all of the other appropriate options that are available. The attending healthcare provider refers the patient to a consulting provider who then independently evaluates the patient to confirm their eligibility for medical aid in dying. And if either the attending healthcare provider or the consulting healthcare provider has any concerns, they must refer the patient to a licensed mental health provider for additional evaluation. The licensed mental health provider then confirms that the patient is either capable of understanding and making the decision or is not and is acting voluntarily. Those must be clarified. The patient then submits written request in the form to attend the attending healthcare provider. It must be signed by at least one witness who is not related to the patient and cannot benefit in any way, and it also cannot be the attending provider. The attending healthcare provider reviews the consulting healthcare provider's report, and if it does not confirm eligibility, then there will be no prescription. It cannot happen. If the attending healthcare provider reviews the mental health professional's report, and if applicable, the mental health capacity to make the healthcare decision is not confirmed, a prescription will not be written. The attending healthcare provider confirms the patient's eligibility for the medication. It informs the patient that they may rescind their request at any time for no reason at all, and recommends that they should be discussing this with their family. And no less than 15 days from the initial oral request, and only once in all of these steps have been carried out, may the provider write the prescription for the aid in dying medication. So I have everybody who is here in the yellow shirts is here in support of this bill. We know that when someone knows that they're going to be dying, they want to have some control over how it's done. These, people face extraordinarily painful situations. And in my conversations with my friend who was our colleague, she would like to have some agency, some ability to make some decisions for herself so that she has some dignity as she ends her life, which unfortunately the disease that she has is going to end it for her. I'm working with a group called Compassion and Choices. We have here with us Melissa Stacy. She works with Compassionate Choices. I have other individuals who are patients and doctors who would like to share their points of view. And if you would not mind, I'd love to invite them up to speak. Do you have any questions for me?
Anyone here to speak in opposition? No, he already got it. Every time.
Clark Barron with the Medical Society of Virginia. We are opposed to the bill. Foremost, I want to thank Senator Boysko. This is not a fun issue to talk about in your office. She gave us the time and listened to us, which was more than we deserved. If you recall, we have been in neutral on this bill for the last several years. This past October, our membership met in a windowless conference room and changed our position. So now the medical society is opposed to the bill. Plainly, our membership feels that this directly affects and undermines the patient-physician relationship, as well as skews incentives in the wrong direction. We ask you to vote no.
Tom Epps, a family physician from Lynchburg, former president of Medical Society and a member of the AMA delegation. I stand against the proposed PAS bill. I've been a part of a 10-year effort to have the AMA maintain its consistent position against physician-assisted suicide. The Council of Ethical and Judicial Affairs in 2019 affirmed that physician-assisted suicide is incompatible with the physician role as healer. Our profession needs to stand with patients from cradle to grave. The term MAID used in this legislation was totally debunked by CJA. The MAID is only appropriate when hospice and palliative care is done, because that's aid in dying. PAS is medical aid in death. Finally, this law demands that we rely on the death certificate. That if a patient has pancreatic cancer, gets hit by a truck, he died from an automobile accident. This law is asking that they not say the patient died by suicide, but by the primary reason that they decided to want to commit suicide. This is a problem in every state where this is currently the law, and doesn't allow the Department of Health professionals to gather the data to know what is going on.
My name is Nicole Davis, and I'm representing the Virginia Association for Centers for Independent Living. We work with people with disabilities every day who are navigating systems that shape their choices long before a doctor ever enters the room. This bill is often framed as expanding choice, but choice is not real when the systems that make living possible are broken. When people face caregiver shortages, long wait lists for services, inaccessible housing, untreated depression, or simply the fear of being a burden, those are not neutral conditions. They are systemic pressure, and systemic pressure can and often do function as a form of coercion. Public policy should never present death as a solution to simply gaps in services. In that context, offering death is not compassion, it is a response to unmet need. People with disabilities are often told, explicitly or implicitly, I could never live like that. But disability itself is not the problem. Thank you.
Good afternoon, Mr. Chair, members of the subcommittee. I oppose expanding assisted suicide in Virginia, and I speak today on my own behalf and from the perspective of the disability community, a community that cares deeply about how our laws affect people who are often overlooked. Supporters often say people seek assisted suicide because their suffering is unbearable, but data from Oregon tells a different story. Most recently, only 34% of people cited concerns about pain. By contrast, nearly 89% feared losing autonomy, 88% feared losing the ability to do things that make life enjoyable, and 64% feared losing dignity. Those are not primarily fears of physical agony. They're fears of disability, dependency, and loss of control. Millions of Americans with disabilities live with those realities every day, and we're not undignified, lacking in autonomy, or unable to experience joy. When disabled people are isolated or dependent, thank you.
My name is Nikhil Chandravel. I'm a VCU medical student speaking on my own behalf and all these lovely future doctors here, my classmates and Comfort. We just want to express our opposition to this. Thank you.
Thank you, Chairman. My name is Comfort Aluko. I'm a fourth-year medical student at VCU Commonwealth School of Medicine, and I wanted to speak on the perspective of these patients outside of the hospital. Physicians who talk with these patients for 10 minutes at a time over time only have a brief snippet of the quality of life that these patients have outside.
We're not going to add another minute and you have 6 people behind you.
Their quality of life is beautiful when they have the supports they need. That's what we need to focus on.
Try to make this quick. Chairman Bagby, committee members, I'm Dr. Don Stern. I'm a retired physician in Hanover County after 36 years with the Virginia Department of Health.
including a year and a half as commissioner. My wife was diagnosed 7 years ago with stage 4 colon cancer. She's sick. Huh?
Really, forgive me. We've read all of the emails that you all have sent.
Good.
We've heard the stories, and we understand your positions. We do want you to be able to say you're here and your position, but we can't hear the testimony, the full testimony from every person here. So if you can just come up and state your position and allow the other folks to.
Is also opposed. You've not heard her story. And I understand why these folks would want this for their patients. But thank you for your time.
Thank you. My name is Blake. I practice clinical psychotherapy here in Richmond, Virginia. And after bills with completely identical rails have been put in place, they have still been used to offer medical aid in dying to 30-something-year-old women with anorexia who could have been treated and helped. Please think of them.
Good afternoon, Mr. Chair. My name is Dr. Muncie. I'm a hospitalist for the past 12 years. In 12 years of conversations, the biggest gap I've seen is in resources for patients so that they can make choices. We need to look at Medicaid, Medicare, and the options available for hospice and palliative care. I am opposed to this bill.
Hello, my name is Andrew Lyle. I'm a board-certified family physician here in Richmond, Virginia. This bill will undermine the trust I have with my patients, particularly patients with disabilities and people of color who will rightly fear that their doctor will prioritize an early death through physician-assisted suicide rather than continuous treatment or long-term care. Healthcare insurances and hospitals will stop covering the life-saving treatments that I prescribe because they will find out that it is cheaper for physician-assisted suicide rather than actual medical care. Cases have already been seen of this in Oregon and California. This bill is bad for Virginia.
Jennifer Hubert with the Virginia Society for Human Life, and we hope you'll oppose this bill on the grounds that it puts vulnerable communities at risk. Thank you.
Hello, I'm Dr. John Markley. I'm an infectious disease doctor and internal medicine doctor. I oppose the bill. I just want to say that our suffering patients don't need to be eliminated. They need to be cared for. And when the state affirms assisted suicide, the message heard by our vulnerable patients is, yes, you are a burden. Yes, you are less valuable. And yes, you are better off dead. That's not dignity. That's despair codified into law. Please be courageous and oppose this bill. Thank you.
I'm Dr. Sheila Fury. I'm a psychiatrist. I see tons of patients who are terminally ill. I never recommend suicide. Never. And as a physician, if a person comes to me and says that they're suicidal, I have an obligation to protect them, and I do so. And I will never refer any patient in my practice to another physician who gives medical assistance in dying or death.
Good evening. My name's Jonathan Holgis. My father was a doctor. My mother was a nurse. I've had 4 very close members of my family, including my daughter-in-law, die long, slow, painful, miserable deaths. Dr. Singh Sani here in town did over 40 ablations of cancer in my daughter-in-law's head. She still died of cancer. We are not the authors of life. This is a stupid bill. It should be killed.
Those who are speaking in support, I'm going to start at 7 minutes.
Good evening, Chairman, members of the committee. My name is Melissa Stacy. I'm with Compassion and Choices Action Network. Medical aid in dying is a widely supported, patient-driven end-of-life option. It is a trusted and time-tested medical practice. SB 359 balances patient autonomy and safeguards to protect both patients and providers. I'm here today as an expert on the bill language and to be a resource on this proven practice across the country. I would respectfully urge your favorable vote on this essential legislation. And I'm going to ask that just those that are here in support, if you could just please stand up for a moment or raise your hand. Wonderful, thank you.
My name's Constance Musenti, a resident of Nelson County. For 25 years, I've lived with and treated cancer, and now it has spread to my bones and my liver. My oncologist reports that my liver will start to fail within 3 to 6 months. I've been offered experimental drugs requiring long hospital stays and side effects that I'm unwilling to accept. I do accept, respect, and honor the fact that I am mortal. And it's extremely important for me to maintain control over my final days before my quality of life has totally deteriorated. Within months, I'm likely to be experiencing intractable suffering with palliative care not really relieving me. Rather than enduring a slow, unbearable decline, I want the legal right to choose medically assisted dying for a humane, peaceful, compassionate end, with my loved ones by my side, sparing them from witnessing a prolonged traumatic death. Thank you, and I hope you will pass this bill.
Honorable Chairman and members of the committee, I'm Zubair Al-Hassan. I graduated from medical school in 1960 and retired 5 years ago. Out of those 60 years, I spent more than 50 as a cardiologist in various roles, mission hospitals, Medical College of Virginia in teaching, VA hospital and private practice. I was against aid in dying, particularly when Dr. Kevorkian started practicing his lone practice without adequate controls. But a few years ago, Dr. Latnivier, my close friend and very conservative doctor, he convinced me to think about this again after one of his physician friends had to resort to suicide and shooting his wife because he couldn't bear to stand the pain that his wife was bearing without adequate pain control. We as doctors know how to treat patients. We know better than the patients, but we can never understand the anguish that a patient has as much as they do. I have come to think about the problem and have joined Dr. Latnivier, who was cited for his outstanding service to the Commonwealth and to the country last year by this assembly. I believe there have been a lot of straw men raised by the previous speakers who are against this. The bill that is in front of you has all the controls to prevent any kind of misuse, and I urge you strongly to support it. Thank you.
Good afternoon, Mr. Chair and members of the committee. My name is Wayne Swatlusky, and I live in Richmond. I'm an ordained Catholic priest, now resigned, and a volunteer with hospice. I've been with people who were dying. Some deaths have been peaceful and relatively pain-free. Others were marked with prolonged, unnecessary suffering. I don't pretend to know the will of God, but I do believe that my God is a compassionate God, and medical aid in dying is a compassionate end-of-life option, completely voluntary for eligible patients. You may be morally opposed to medical aid in dying, which I totally respect, but your affirmative vote need not compromise your belief, but rather reflect your understanding and respect for those of us for whom it is not morally incompatible. I ask for your vote to legalize medical aid in dying. I am also disabled, and I'm not afraid of being coerced into anything that I don't want to be coerced into. Thank you.
Mr. Chair, with the last couple of minute and a half, I have a letter from someone who couldn't be here. Would that be okay for me to read it? Is that okay? Okay. This is someone who is from Massachusetts who spoke on this. As a resident of Massachusetts, ever since I came to college here in 1956 and graduated from Harvard Medical School in 1964, I completed my residency in psychiatry at the Massachusetts Mental Health Center in 1968, and I'm honored by the opportunity to offer testimony in support of an act of relative end to life options. As a member of the American Medical Association Council on Ethics and Judicial Affairs from 2012 to 2029 and chair of the council from 2018 and 2019, I had the privilege of leading the council's review of the AMA policy regarding what the AMA called physician-assisted suicide. We concluded that the 25-year-old opinion that has declared it to be unethical represented the views of physicians who oppose it, but that equally wise, caring, ethically oriented, and thoughtful physicians believe that it should be legal and available as an option to consider at the end of life. A summary of our conclusions are here, which were approved by the AMA House of Delegates in 2019. And I have those to share with you. As a psychiatrist now retired who practiced and taught for decades in Massachusetts, I respect the views of those who oppose it, but I strongly support the option for having medical aid in dying. I have studied the experience of states that have made the option available, and I have probed the issue deeply with health professionals concerned with end-of-life care and hope that we will approve the act. If the Public Health Committee or if its members wish to discuss it, I'll be happy and honored to do it. And that was written by James E. Sabin. And I would just like to go over the AMA, the American Medical Association's position on medical aid in dying. From 2016 to 2019, the American Medical Association Council on Ethical and Judicial Affairs spent 3 years reviewing the AMA's historical opposition to the practice of medical aid in dying. And in 2019, the AMA upheld its oppositional position on medical aid in dying, but there were key findings. The policy position was adopted for the first time. The AMA affirmed that physicians can provide medical aid in dying according to the dictates of their conscience without violating their professional obligations. Striking a balance, the AMA highlighted 2 separate provisions of the Medical Code and Ethics as relevant and applicable to medical aid in dying, establishing that physicians who participate in medical aid in dying are adhering to their professional ethical obligations, as are physicians who decline to participate. This position allows for and respects and supports the diverse views of the AMA membership. According to the AMA's CEJA report adopted by the AMA's House of Delegates, guidance in the AMA Code of Medical Ethics encompasses the irreducible moral tension at the stake for physicians who, with respect to participating in this policy. Opinion E-5.7 powerfully expresses the perspective of those who oppose physician-assisted medical aid in dying. Opinion 1.1.7 articulates the thoughtful moral basis for those who support this policy. In addition, the AMA affirms that euthanasia, defined by the administration of lethal medication by a physician for the purpose of relieving suffering, is distinct from medical aid in dying. So, a couple of things that we've heard about: people are afraid that people with disabilities are going to be coerced. There are safeguards, which I've read to you already, that talk about the person has to have a terminal illness. Anorexia is not a terminal illness. It would have to be something where they have an absolute terminal illness, mentally capable, have to be adults with a prognosis of 6 months or less to live, and they have to be vetted by their provider, they have to be vetted by another provider. If there's anything in question, they have to be vetted by a mental health care person. And then, again, they have to be able to have a conversation in private with nobody else around to confirm these things before they would be allowed to do this.
Thank you.
I think it is
Thank
a
you.
passionate
Thank you.
thing to do.
It's with the committee.
Mr. Chair.
Senator DeBrandt.
I've got I'd like to comment on the bill when appropriate.
Go right ahead. This is the moment.
Thank you, Mr. Chair. I was just reviewing the AMA's Code of Medical Ethics, and I did see that opinion that the patron was citing, but ultimately right front and center, it states that it is, though tragic when patients under extreme distress, permitting provisions to engage in assisted suicide will ultimately cause more harm than good. It's fundamentally incompatible with the physician's role as a healer. It'd be difficult and impossible to control and impose serious societal risks. I think that while I'm by nature, I don't subscribe to a slippery slope ideology. I think that's can be problematic in theory, but I have grave concerns. But I've been following this issue, and I will say that I will set aside one of the testimonies from someone, and I thank all of you for coming. That if you have that moral incompatibility from your own faith perspective, that you can still set that aside. And I think from looking at how some of this has happened, not only in other states and the guardrails that you have put thoughtfully into this bill, it still leaves me some serious concerns. And I've watched, particularly in Canada, the MAID program, the Medical Assistance Program. There, last I saw 5 months ago, there have been 428 cases tracked of possible criminal violations. They've got same-day response, and over again we see those who've said they were trying to request help and they were instead being referred to the MAID program when they were instead trying to get I think there was a veteran that was trying to get a wheelchair and had not been able to get a wheelchair and instead was referred to the MAID program, where recently, just a few days ago, there was an elderly lady that her husband had caregiver fatigue. It was a heartbreaking situation, and she changed her mind. But the same day response was ultimately provided that euthanasia. I have such grave concerns about those who are vulnerable, and that whether or not our health insurance, would push that it would be less expensive to refer them and not instead lean in and ensure that they were getting the care that they deserve. So it is, for those reasons, I can't support the bill. Thank you.
Thank you, Mr. Chairman. I would have great concerns with this bill probably 20 years ago. In the last 20 years, those would have just increased so dramatically. What we've seen from insurance companies during that time and what we see with the marketing abilities, tools that they also have through social media where you can direct getting this information to folks to really encourage this behavior when in their analysis, this is worth millions of dollars, and it is incentivizing the end of life through the worst form of capitalism. And I don't think that we should be doing this at all. And I think that we should all have far greater pause right now with what we've seen over the last 20 years.
Is there a motion?
I will make a motion.
You're looking at me. Mr. Chair, I don't know where you are on this. I do think there are enough guardrails in the bill, and I think that was some of the sort of the theme going on here, that folks thought it could be misused, or an individual would not be of full mind and ready to make that decision. But 170 to 179, you do talk about a witness needing to be available. and the fact that the individual has to be of sound mind. I can see that if used properly, this could be a tool that individuals would find helpful, if you will. It's a very difficult topic, for sure. I don't know where the committee's going to end up, but I'm getting a sense that my colleagues feel there are not enough safeguards, that this is not the kind of thing that you would support. Is that a fair statement?
I will make a motion. Mr. Chairman, I move that our subcommittee recommend the bill be passed by indefinitely.
There's a motion and a second that the bill be passed by indefinitely. Clerk, call the roll.
Senator Bagby?
No.
Senator Suderline?
Yes.
Senator Aird? Senator Durant?
Yes.
Senator Perry?
No.
Senator Favola? Ayes 2, noes 3, 1 abstention.
Ayes 2, noes 3, 1 abstention.
So for ease of the reporting that'll come before the full Committee on Education and Health, I will make a motion that the bill be reported to the full Committee on Education and Health. The hearing will be Thursday morning.
There's a second by Senator Perry.
Senator Bagby?
Aye.
Senator Suderline?
No.
Senator Aird?
Abstain.
Senator Durant?
No.
Senator Perry?
Aye.
Senator Favola?
Aye.
Ayes 3, noes 2, 1 abstention.
Ayes 3, noes 2, 1 abstention. You got some work to do before.
Thank you, and thank you for your careful, thoughtful conversation. Appreciate it.
Senator Carrefour.
Thank you, Mr. Chairman, members of the subcommittee. My first bill is Senate Bill 596, right to contraception. Before I begin, I would like to move.
Folks to just leave quietly. Thank you. And Senator Carrefour, thank you for your patience.
No worries, thank you. I would like to move the amendment.
Is there a motion?
Move the committee amendment.
Is there a second?
Oh, it's a substitute? It's a substitute. Move the
I would
substitute.
like to move.
Is there a second?
Amendment in nature of a substitute.
Is there a second?
Second.
Second.
You want to second your own? There's a motion and a second. All those in favor express by saying aye.
Aye.
Those opposed? Senator Carrefour.
Thank you, Mr. Chairman. The revised bill cleans up definitions of contraception and contraceptives to make it clear that the drug need not be used to prevent pregnancy to be protected. It can be used for non-contraceptive purposes such as treating endometriosis, uterine fibroids, ovarian cysts. A contraceptive is defined as any FDA-approved contraceptive product and doesn't turn on the marketing of the contraceptive. Second, the right is fleshed out more to clearly include the right to obtain contraception and provide contraception, so long as the provider is acting with the scope of their practice and property license. Third, the bill makes clear that a right to contraception exists in Virginia, even if the Supreme Court overturned the current federal.
I'm sorry, Senator. Are you explaining the substitute, the difference in the difference, not the full bill, but the?
Yes, sir.
Okay.
The difference
Okay.
between the substitute and what was previously before you.
Okay.
And the third, the bill makes clear that a right to contraception exists in Virginia, even if Supreme Court overturned the current federal right. It makes clear that this right prevents hostile actions by state or local government. And the fourth thing it does is that, working with Senator Perry, the language now requires that any law or policy interfering with access to contraception may be enforced only if the Commonwealth can demonstrate by clear and convincing evidence that the restriction is consistent with widely accepted evidence-based clinical practice standards. This language was substituted to do two things. One, assign the burden of justification to the government rather than the individual or provider, and anchor judicial review in objective medical standards rather than open-ended balancing or legislative differences. I believe that the substitute reduces ambiguity, limits the chance of varying judicial interpretations, and makes it harder for restrictive laws to survive a challenge without an evidence-based justification. And I believe it also addressed Senator Favola's concern as well.
All right. Any questions from the committee? Anyone here to speak as it relates to the substitute? Either one.
Mr. Chair, members of the subcommittee, Jeff Caruso with the Virginia Catholic Conference. You heard my testimony last week, so I'm not going to reiterate it, and I really respect the committee's time last week. However, I do want to say again that, just to repeat, this does go beyond Griswold in several different respects. Again, one, this applies to minors. Secondly, this applies to sterilizations. And third, it would allow potentially minors to get sterilizations without parental consent. So it does go beyond Griswold. I just want to point that out to the committee before you vote. Thank you.
I'm Dr. Sheila Fury. I oppose this legislation. First of all, you're creating a right where none exists. Second, when you're extending this to minors, there are significant problems with giving contraception, both oral, implants, and surgical, to minors. First of all, the birth control pill as well as implants can cause significant depression and anxiety. I have, in my practice, had young girls come into my practice who were immediately suicidal after an implant of birth control pills. Imagine if their parents never knew that they had an implant or had newly started on the birth control pill and are now suicidal. Further, these interrupt the entire endocrine system of women. Additionally, the permanent contraceptive have a direct impact on brain development. In young girls who begin taking contraceptions earlier, they have a direct implant, especially surgical removal of their ovaries, directly impacts the brain development of that child. Why are we harming our children?
Hello, Chair, members of the committee. Jennifer Hubert with the Virginia Society for Human Life. Excuse me, it's been a long day. Our opposition to this is strictly on the fact that this does not clarify the definition of contraceptives if in the event that the FDA categorizes abortifacient drugs such as mifepristone as a contraceptive, which it is not, but they could define it as such, and does not allow for conscience rights. That's our bigger concern, is that it doesn't allow for conscience rights for medical personnel who would object to prescribing these medications. Thank you.
I have a quick question. Were you present for the previous bill, during the previous bill that we just heard in here? Or were you obligated elsewhere?
Yes, I was here.
You were here, okay. I now have a question for the patron then.
Senator Careful. Senator Careful. I'm sorry, sir.
That's shocking. Thank you, Senator Carol Foy, and thank you, Mr. Chairman. Thank you, Senator Carol Foy. I've got a few questions about the legislation, which I think we covered a fair bit last week. One of the questions is the entities that could be sued in this with the right of action is, to my eye, only government entities. Is that correct?
That is correct.
Thank you, Mr. Chairman. Thank you, Senator Carroll. Another question I have is to understand the goal with this on the inclusion of sterilization on line 16, and I'm then trying to see later references in there. Is there an assertion by this bill that there is a right to sterilization or that there is a right to information about that, including the other information?
Mr. Chairman, I would say to Senator Suline, this bill does allow for contraceptive uses, and in this bill, it does make clear that sterilization is one of those processes that can be utilized. I just want to clarify something that was previously said as well. Minors do not fall under the purview of this bill. Code section 54.1-2975 specifically states that minors cannot consent to any type of sterilization process. Sterilization operations for certain children are incapable of informed consent. So that's addressed there. But this bill does say that contraception, the right to it and to be provided it is would be protected under this bill.
Mr. Chairman, if I may? Yep. Thank you, Mr. Chairman, and thank you, Senator Carol Foy. Would you consider it friendly to have that sentiment expressed in this bill as well, so that it's reiterated in this specific bill to make it clear that this is a discussion of Virginians over 18 years old, instead of it being silent in this bill and have to look elsewhere for the reference? Because I think that if that was stated in here, I think that could be helpful.
Brief indulgence.
Do you think that's a friendly amendment? Are we restating what already exists?
Yes, we are.
Yeah.
Okay.
So why are we doing that?
Okay. All right. I don't believe that there is an objection to, I guess the pause is that there's also already Virginia Code section and law that says that minors cannot consent to sterilization. It's not a possibility in Virginia. The code section is 54.1-2975. So that is already the law, that a minor cannot consent and cannot be sterilized in Virginia. So I give pause to be redundant, duplicative, or to cause some type of confusion to restate it in this bill, because it only applies to adults.
Mr. Chairman, I would just suggest something to ponder, is that, because I think that if that were reiterated, if that was reiterated in this legislation, it would be helpful in the conversation.
Council, can I ask council a quick question? Council, can we point to that section of the code in there?
Mr. Chair, in subdivision E2 of 54.1-2969, it provides that a minor shall be deemed an adult for the purpose of consenting to medical or health services required in case of birth control, pregnancy, or family planning, except for the purposes of sexual sterilization. So it is, a minor cannot consent to sexual sterilization. However, under the code, a minor shall be deemed an adult and therefore can consent to medical or health services required in the case of birth control, pregnancy, or family planning that do not include sexual sterilization.
Mr. Chairman, I guess if I can inquire from Senator Suline, if it's to get him to a yes and he would feel more comfortable having the code section reference, then
Yes.
I find that as a friendly amendment.
Council, can you reference that in that? Done. Is that a motion?
I move that we reference the code section.
Is there a second?
Second.
There's a motion and a second. All in favor express by saying aye.
Aye.
Those opposed? Senator Carrefour, you want to close us out?
I think the only other thing that I would want to just ensure to bring home is that contraception has been a game changer. It's about autonomy, it's about healthcare, it's about economics, it's about empowerment. And if you believe that women should control their own destiny, then please vote for this bill.
Is there a motion?
I'll move the report.
There's a motion and a second to report. Clerk, call the roll. As amended.
Senator Bagby?
Aye.
Senator Suderline?
Yes.
Senator Aird?
Aye.
Senator Durant? Senator Perry?
Aye.
Senator Favola? Ayes 5, noes 1.
Ayes 5, noes 1. Thank you.
Thank you. And the last bill that I have is Senate Bill 721, Maternal Health Monitoring Pilot Program. Before I begin, I do have to ask the committee to adopt a substitute.
Is there a motion?
So moved.
Is there a second? There's a motion and a second. All those in favor express by saying aye. Those opposed? All those in favor express by saying aye.
Aye.
Those opposed? Ayes 1, no 0.
Thank you, Mr. Chairman. I do want to first acknowledge that Phillips, Diabetics Leadership Council, Avid Mel, and March of Dimes all have submitted letters of support for Senate Bill 721. What this bill aims to do is to create a pilot program that will follow 500 high-risk individuals to check for high blood pressure and preeclampsia. And so we know that hypertensive disorders like preeclampsia and gestational diabetes often have few symptoms until they reach a crisis point, such as stroke or seizure. We know that it's worsening, that 30.8% of Virginia counties are maternity health care deserts. And between 2015 and 2022, pre-existing hypertension rose 80% and pre-existing diabetes 50%. And so we know that remote pregnancy monitoring has been linked to long-term success. It's a way for moms to be connected with devices like glucose meters, blood pressure cuffs and scales to monitor their vitals. And as soon as there is something that happens, it's like a check engine light with complications, and a remote care team will immediately intervene and notify emergency services or the primary care physician, or OBGYN, so that way the mom can be taken care of. And so that's the bill.
Senator Bagby? Senator Suderline? Yes. Senator Aird? Senator Durant? Yes. Senator Perry? Senator Favola? Ayes 6, noes 0.
Thank you, Mr. Chairman. Thank you, members of the committee.
Thank you, Mr. Chair. 32nd bill. This is a agency bill that just helps with efficiency. It amends its Senate Bill 736, and it basically just amends the code section where that the state local hospitalization program is no longer funded by the General Assembly and as such no longer operated by DMAS. However, the report mandate remains in the code requiring DMAS to submit a cover letter to the General Assembly each year stating that this program is no longer funded, no longer in operation. This creates inefficiency in staff time and unnecessary reporting. By amending this language to make the report due only when the General Assembly appropriates funding to the program.
Senator Bagby? Senator Suderline? Yes. Senator Aird? Senator Durant? Yes. Senator Perry? Senator Favola? Ayes 6, noes 0.
Thank you, Mr. Chair.
Senator Martin. While you're staying there, Senator Martin, Senator Suderline has a bill. Senator Suderline, you have a motion?
Yes, Mr. Chair. I move that my bill be continued to 2027 and Senator Durant by proxy seconds.
All those in favor? Clerk, call the roll.
Senator Bagby? Senator Suderline? Senator Aird? Senator Durant? Senator Perry? Senator Favola? Ayes 6, noes 0.
6-0, we'll hear this bill by Senator Martin, then we'll hear this bill by Senator Favola, then we'll go home. Senator Martin.
Thank you. I've heard the definition that home is the place that when you go there, they have to let you in. So, at any rate, I'm here today to present Senate Bill 483. Senate Bill 483 provides critical support for tribal health services by requiring that the Department of Medical Assistance Services consult with Virginia's federally recognized tribes when preparing the state plan for Medicaid. Consultation is an important aspect of the government-to-government relationship between the Commonwealth and its federally recognized tribes. The bill codifies and strengthens the Department of Medical Services' existing consultation obligations under federal statute, federal regulations, and Virginia's Medicaid state plan. This bill is unanimously recommended by the Commission on Updating Virginia Law to reflect federal recognition of Virginia tribes, which is a bipartisan commission that has members from both houses and all 7 federally recognized tribes. However, since the bill was first proposed, we have heard from the Department of Medical Assistance Services that they have concerns about the bill, which we are currently working through. My understanding, and I've just confirmed it, is that the chairman of the commission, Delegate Krizak, is setting up a meeting with the department and representatives of the tribes to come to an agreement on a substitute. So what I'm asking the subcommittee to do today is to approve this important bill as it was introduced, with the understanding that we will have a substitute bill for the full committee to hear on Thursday, and I have confirmed that with DMAS, who is here today. And so that is the bill. And
Mr. Chair,
Senator Aird.
I don't mean to slow the train down, but I don't want to be the opposition, so can I ask a question?
you certainly can.
Okay, so I respect the fact that the bill is still being worked through, but because we have limited testimony in full, it would be really helpful to get some guidance on what exactly is the sticking point that's being worked out, so I have some context and to consider.
I can take some brief testimony at Education and Health.
But is he able to answer?
She wants to know what they're considering right now.
Yeah.
Yes, to get that answer, but I will, because
I've got some information on that, but
I think I am going to have to take brief testimony at Education and Health, which I do on occasion, but please answer her question in terms of what's being worked on, what the issue is.
I think I could best explain it by bringing up my friend here.
Mr. Chair, members of the committee, Deborah Rodman on behalf of the Nansemond Indian Nation and the Rappahannock Indian Tribe. This bill came out of the Tribal Code Commission, and we just heard from DMAS this last Thursday, and it's just giving us time to find out what their concerns on. 7 tribes have committed to this legislation, Mr. Chair and Senator Aird, and so we really want to work this out and have this meeting. It's about consultation, so that's why we're trying to move forward on consultation.
I'm sorry. Tell me what the issue is one more time.
Right now, as the bill stands, DMAS would like to strike a good portion of the bill and insert other consultation language that comes from the federal level, and we would like to work on
Yeah,
that language.
maybe DMAS will provide a little more color to that.
Mr. Chair, Will Frank with DMAS. We saw this bill as it passed through the tribal committee. We were not approached to provide any assistance in the development of this, so we presented an amendment that would bring it in line with existing consultation, what we're required to do based on federal government. There's some discussion back and forth about that amendment. We've agreed to have further discussion over the next 24 hours, basically, about that. We have some concerns with some of it that goes kind of beyond what that current tribal consultation is, but we're happy to continue to have that discussion by Thursday.
Okay. Thank you. I guess we'll learn more on Thursday.
Mr. Chairman, my understanding is that we're all trying to get to just the right place on the bill. There's no substantial disagreement that consultation is a good thing and what have you. We just want to get it right and make sure the federal and state law all match up and that everybody is comfortable with the bill.
Are you sure you want to speak now? No, I mean, because if you speak now, then you don't speak at the next meeting.
When all of us are there.
once this is cleared up. So do you want to speak now or then?
Yeah, you want to wait, I think. Mr. Chair, we don't need a recommendation on this for the full committee. We'll just put it on the docket and we'll have to take some testimony.
Okay, we'll see you then. Thank you.
Thank you so much. Senator Favola,
Oh, thank you.
it's only right that you close us out.
I'm going to close you out? Okay, great. It's Senate Bill 332. I don't think I have anybody speaking on this. Do you want me to present it here?
You can present it in the parking deck.
Well, maybe I won't do that, but
Either way, I'm voting for you, Bill.
either way, it's what this bill does is it just allows a hospital to use medical cannabis under a prescription, but there is a substitute, so I would move the substitute.
Second.
There's a motion and a second on the substitute. All those in favor express by saying aye.
Aye.
Those opposed?
Thank you, Mr. Chair. The cannabis, medical cannabis is currently available and can be used in a nursing home, a hospice facility, or assisted living facility. We are just adding hospital to the current statute. And there is a regulation that we're also amending, which happens to be referenced in statute. So line 569 of the bill, page 22, says, again, a hospital and nursing home. So I added hospital, nursing home was already in there. The individual would still need a prescription for the medical cannabis. And for the most part, in the nursing homes and healthcare facilities, they use the oil. So that's my bill.
Mr. Chairman, I move the bill report.
Second.
There's a motion and a second for the bill to report. Anyone here to speak in opposition? Anyone here to speak in support?
I worked my bill.
We can tell.
I worked at the HHA.
There's a motion and a second. We'll go back to the motion in a second. And clerk will call the roll.
Senator Bagby?
Aye.
Senator Sudaline? Senator Aird?
Aye.
Senator Durant? Senator Perry?
Aye.
Senator Favola?
Aye.
Ayes 4, no 0, 1 abstention.
Thank you.
Thank you.
One abstention. All right, we have all expired.
Gosh, what a meeting.
God forbid.
Thank you for joining us. This concludes this broadcast of the Senate of Virginia in Richmond, Virginia. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, C311.